All persons having business with the appellate division are here. To the attendance, you shall be heard. Please be seated.
Welcome to the Appellate Division, First Department. As I call the calendar on this election law calendar, please ask for the time that you actually need. Remember that the panel, if we have additional questions, we'll ask them and you'll have time to answer. We've read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know who you're representing and how much time you're requesting. Fisher versus Board of Elections of the City of New York. And how much time do you want? 15 minutes. How much time do you want? Okay, I'll give you 5 and 2 and 5, and if we need more time, we'll take it. Thank you. The second case is Alietto v. Commissioners. Yes.
We asked for 10 minutes, but I believe you can do it in 7 minutes, Your Honor, with 2 minutes for rebuttal.
You're the petitioner.
I'm the petitioner, Alietto.
Thank you.
The respondent, Board of Elections, 3 minutes, Your Honor.
Is anyone here for the interveners?
Aaron Foldenauer for the interveners, 7 minutes.
Okay. I'll give you 6 and 2, 3 for the Board of Elections, and 4 for the interveners. Thank you. First case up is Fisher.
Step up.
Please.
Thank you, Your Honors. Good afternoon, and may it please the court. As I said, I am here on behalf of the petitioner, Ms. Corinne Fisher. There's a few brief points, Your Honors. I'm well aware that you've all read the paper, so I don't want to overindulge. But first and foremost, Your Honors, the CPLR 3022 directly states that if a verified pleading is thought to be defective and it's treated as a nullity, meaning it's not going to be
You need to have tell your opponent with due diligence.
with due diligence. That's
So
correct, Your Honor.
you all served it, I believe, on Friday afternoon about 3 o'clock.
That is correct, Your
And
Honor.
they didn't object until the morning of Tuesday.
That is
So
correct,
it's
Your
a
Honor.
business day plus a few hours.
That would be correct. Your
Why is that not due diligence?
So, Your Honor, the way we have read the case law is that it says, while there's not a specific decision on how quickly due diligence or what due diligence is defined
Do you
as.
count non-business days in the determination of due diligence?
I apologize, Your Honor, I missed the first.
Do you count non-business days, weekend days, in a determination of whether there's been due diligence?
In a case such as this, Your Honor, where there is a very quick turnaround in these election cases, I would submit that it should be beyond the business days. But even if we were to just look at the business days, Your Honor, they had from Friday afternoon, those last few hours of the business day on Friday, and then all of the day on Monday while they were preparing their papers, Your Honor, versus advising our team literally at the courthouse and handing the papers over with this argument.
It's not the only thing they're doing on Monday.
And
It's not the only thing they have to work on Monday.
Perhaps, Your Honor, but as they're making the argument, as they're
the petition included other arguments that they were looking to gather information to respond to as well, right?
Of course, Your Honor. I would just respectfully submit that as they're preparing these papers, Your Honor, they knew that this was one of their arguments. I would submit was one of their main arguments. They could have easily picked up the phone, sent over an email, and advised that they.
So in your estimation, due diligence means that as soon as they realize this, and you're assuming that they realized it that next day, when on Monday, that they were required to inform you?
That is correct, Your Honor. As they were preparing their papers, admittedly, even if it was in the later evening hours, Your Honor, or even first thing that morning, right?
Are there any cases that say that that is the definition of due diligence, that as soon as they find out, they have to make a phone call and let the other party know?
There was one case, Your Honor, and if you bear with me, I believe it was the matter of Lee versus Orange County Board of Elections, where it said that it should be immediately or within 24 hours. But again, that was a general case, and so or it was not a general case, but in these cases where the election process and the hearings happen so quickly, we would respectfully submit that there should be some, importance given to due diligence and providing the other side with a notice of the defect that they're alleging.
Counsel, if we agree with you, what about the merits? In other words, if you get around this verification problem.
Sure, Your Honor. We would submit that on the merits, we would also be successful because notice was not received. And not only was it not received by the petitioner and even her person that was to be given notice, the rules that we've cited in our papers, Your Honor, and I'm happy to go back and provide them on the record, but they provide that once the petitioner has accepted email as the method of receiving communications, that can be the sole method and that should be the sole method. And these notices were not provided via email. The April 7th one in particular is the one where the Board of Elections has stated.
You received a prior NCN, hadn't you?
We received a later one, actually.
A later one, which
Judge.
you did correct quickly?
April 9th. That is correct, Your Honor. It was corrected within the next day. And in fact, at some point, I believe the petitioner tried to correct everything once she was provided notice of having allegedly been sent this first notice of April 7th. But the board is still submitting that it's not, has not been properly corrected. But the April 9th notice, which was received, was corrected within the time frame, Your Honor. For purposes of
The board makes much of the fact that you have 100 non-compliant cover sheets.
That was part of the April 7th notice, Your Honor, was that there was issues with the cover sheets. The April 9th notice had to do with a different issue. There was also
Well, how do you deal on the merits with the 100 non-compliant cover sheets?
Our position, Your Honor, is that we didn't receive the notice as we should have. Well, we didn't receive it at all, and because it wasn't sent via email, which would have then, been received, and they would have complied just as they did with the April 9th notice that they received, they timely, responded and corrected the deficiency. And I will note also, just again, for purposes of the record, there was a timing issue that the board did raise in their appeal opposition here, Your Honors, in terms of the timing. And here they had said that the petitioner had to respond within 3 days of the date of the letter. While the notice was sent on April 9th, it wasn't received until April 11th, but 3 business days was still April 14th, that Monday, Your Honors, because the April 9th was the Wednesday. So the petitioner did respond timely to that second notice. And we would submit, Your Honors, here, there's also no prejudice to the board had the court...
You can finish the thought.
Had the court allowed or considered the argument that the verification had been a nullity and that we should have been provided notice about that.
Okay, thank you, counsel. You have time in rebuttal.
Thank you so much, Your Honors.
Good afternoon, Your Honors. Grace Pian for the Respondent Board of Elections. So may it please the court,
Just on how notice is conveyed, it's the board's position, is it not, that you are required to give notice by overnight delivery?
Yes, correct. That is the New York State Board rules and regulations specifically state overnight mail. It does not say email. So we follow what the...
So you're not required to email, and had you emailed, it's your view that wouldn't have been the correct way to do it?
Correct. We follow the rules and regulations, and even
What
in
are
our...
the rules around whether if someone says that they're willing to accept service by email?
Yes, the city board has guidelines, and in those guidelines, it specifically states that the city board may, in its discretion, email candidates. However, we, by practice, only use the overnight mail to comport with the state rules and regulations on that. So the city board guidelines say we may, in our discretion, but in practice, we use the overnight mail.
But in this case, that had consequences, right? Because the statute of limitations ran while the notice was getting to the petitioner.
Yes, Your Honor. We applied this practice across for hundreds of other candidates where we have applied overnight mail, and we conducted cover sheet and petition hearings throughout this process, and we have not encountered any issues like this in terms of timing where, you know, we sent it out overnight mail in compliance with the rules, and we do have proof of delivery, which is on the record to the candidate's contact person, as stated in their cover sheet.
And what about the argument that this is not due diligence by doing this on Monday and having it received on Tuesday instead of on Friday?
Yes, Your Honor. So the due diligence requires a fact-specific basis. The courts consider the particular circumstances surrounding the election law proceeding. In this case, by April 18th, we received it late in the afternoon. The board's legal department at that point had already been served over approximately 50 legal proceedings with order to show causes by Monday. And this is over, to note, the religious long weekend of Good Friday. And so by the time we were preparing for all the legal cases, and the board staff had to be available on Monday to investigate this somewhat complicated fact pattern of the 100 cover sheets at issue. By the time we were able to draft and review and properly investigate, the first notice that we could give to the...
In terms of due diligence, right, in your investigation, the first thing you're looking at when you receive it is a verification, correct?
Correct. And so
you're not even diving into the other allegations in the petition before you look at that verification.
yes, Your Honor, but
So does due diligence require you to immediately advise counsel of the verification issue as soon as you find out?
no, there's the court opinions and case law do not require immediate or within a 24-hour standard. There's no standard. It is based on the fact-specific circumstances in this case, and in the cases cited by the candidate in this instance, those cases were distinguishable in this case. In those cases, for example, in Lador versus Mayor Village, in that case, that argument of the defective verification was not raised in their answer. It wasn't raised in the return date or at the hearing. And in this case, we did conduct the due diligence possible to raise it as soon as possible, which was the following Tuesday morning. So running about 12 business hours since the service of the papers.
And you concede that the board must give notice with due diligence of the nullity, correct?
Our position is that the election law 16-116 requires a verified petition in a special election law proceeding. And this is important because we are working with incredibly truncated timelines where we are relying more so on the personal statements and knowledge of the candidates.
No, I
and the
understand,
petitioners at
you know,
hand.
why we want you, that requirement is there, but it has to be brought to the attention of the other side so they can correct it. No?
Our position is that the verified position, if there is a unverified petition, so if it's a defective petition, we treat it as an unverified petition, and that is a jurisdictional defect, in which case it must be dismissed.
What's your best case on that?
The Tuck versus Board of Elections, in which this court, as recently as 2024, dismissed an attorney verification that was defective, as it stated that the attorney verified that it was based on the petitioner's own knowledge. So there was a discrepancy there. And therefore the court there, and this court dismissed it as a defective verification in a jurisdiction.
Remind me the site of that, counsel, if you have it in front of you?
Pardon?
Citation, if you have it in front of you?
Citation for that?
It's in your brief, I understand.
Yes, yes.
Okay.
It's it's 216 AD 3D 484, First Department.
By asking the question, I don't mean to suggest that its outcome, your answer affects the outcome, but your briefs do discuss the issue. In your view, in the board's view, how many valid signatures did the petitioner submit under 3750 that's required?
So if we assumed that the two late filed cover sheets were valid, if they had been timely filed, and they only claimed one petition volume each, and when we look through the when the unit looks through the
So what's the
petition volume,
total number that you view as?
the total number should have been for mayor is 3,750, and in this case, I believe at best the best prediction would have been about 100 signatures or so.
Thank you, counsel. Please.
Thank you, Your Honors. I would just start by saying that my colleague here was discussing the overnight mail. And respectfully, overnight mail usually is delivered the next day. And so here we had a situation where it was mailed out allegedly on April 9th and it wasn't received until April 11th, and it wasn't received at all. And when it comes to the receipt of delivery, there's not a complete confirmation here because UPS provides that, or USPS had provided that it was delivered, but there's no confirmation via a picture where it was dropped off. It's an apartment building, is my understanding. And so there's no proof that it was delivered to that apartment or was delivered to a mailroom, but petitioner's position, obviously, that was not received.
So
Respectfully,
back to the issue of due diligence regarding looking at the particular unique circumstances of a case. Here we're talking about having received a petition on Good Friday, having reviewed many petitions, many challenges on Monday after the religious holiday, and then providing information about this on Tuesday. Why is that time frame not due diligence?
respectfully, Your Honor, I believe as you were questioning my colleague earlier, the first thing they're looking at is the verification. And so once they realize that, good faith would be to have contacted our office at that point in time, at some point during the 24 hours of that day or 12 hours of that work day. And respectfully, Your Honors, when there's that much turnaround, attorneys, unfortunately, as litigators, sometimes there's long days as we're working on numerous matters. And in this case, when there's quick turnaround on all of these election matters.
So, counsel, how do you respond to the argument that the Board of Election makes that this is just an unverified pleading? We don't have any obligation. If you submit an unverified pleading, that's it. You're out. I mean,
Jurisdictional.
it's jurisdictional, and we have held that.
If I may just answer your question, Your Honor, thank you. We would submit, Your Honor, that if it's not being considered, then it's a nullity. It's just a red herring of trying to distinguish between.
Do you have any cases that say that it's a nullity as opposed to a jurisdictional defect, which we have held? And the verification is bad. We've held it's a jurisdictional defect, right?
Correct, Your Honor.
Do you have any cases that say, no, it's a nullity? And I'm not really sure why that makes a difference, but I'll read whatever you got.
Yeah, we do not have anything in front of us at the moment. I believe, Your Honor, I'm happy to provide that to the court if we have
Well,
something.
the two sentences in 3022 are kind of in tension with each other, and we have to resolve what that means.
Correct. That I do agree, Your Honor.
Okay.
Thank you. Thank you very much for your
Thank you
time.
both.
Thank you.
Okay, Alieto. Please.
May it please the court, good afternoon, Your Honors. Jorge Luis Vasquez on behalf of the petitioner Clarissa M. Alieto, Your Honor. Your Honor, if I may, we're here because of a Scrivener's error. We're here because of an error that started with an additional number on a zip code on a cover sheet that did not confuse the board, did not provide any allegations of fraud.
Is it a Scrivener's error, or is it an error that is precluded under the rules of what should be placed on the petition, which is the name and the correct name of the candidate?
This court in Flax v. Board of Elections 109A.D3D423 considered that exact argument and rendered it a Scrivener's error when it wasn't misleading, when it was no confusion, and where it was simply a minor typographical error.
Is there any dispute that the actual petitions had the correct name?
There's no
voters?
dispute that the petitions had the exact name, and there's no dispute either, as we have the clerk's report, that Ms. Alieto had more than the amount of validated signatures. The amount of validated signatures are
The original
400.
cover sheet had the correct name.
Yes, it did, Your Honor.
Is that of any significance when the substituted cover sheet does not?
Our position that it should be viewed in a totality of the circumstances, namely the petitions that had the valid name as well as the valid zip code. Although there was an extra digit, the first 5 zip codes were accurate. It matched the petition. And that, together with the amended cover sheet.
What's your Scrivener's error claim?
Yes, Your Honor.
Well, what about the name that was supposed to be printed on the bottom above the signature? That printed name was not there.
That's your name, Mr. Vasquez. right?
That is my name. So my name
Your
was...
name is printed on this just above the signature, right?
Yes, it is,
And
Your Honor.
identifying you as contact person to correct deficiencies,
That's
which is a
correct.
slightly different role than the role that you play in the subsequent signatures. But unlike my signature, your signature is very legible. And it says, I can see Jorge Luis Vasquez, and it's there.
As well as my contact information is also there.
So is it your position that you complied in terms of content? You put everything that you had to put on the cover sheet, and you substantially complied with form, which
That's
is...
correct. That
okay.
it was substantially complied with form.
Right.
And if we look at the clerk's report, the clerk's...
That's obviously what the Court of Appeals has said would satisfy the
That's
election
correct.
law.
And
Right. Okay.
yes,
What
correct, Your
about the
Honor.
verification requirement?
The verification requirement, similar to the last case, there was no notice that was put on petitioners, except, unlike the case that Your Honor's heard before, here we served the Board of Elections on or about April 15th with in-person service. We then had oral arguments on April 18th. At April 18th, this was not brought up by the board. On April 17th...
Was it brought up by were the interveners heard on April 18th, first of all?
On April 18th, the interveners made a motion, and the court did hear the interveners.
I mean the board or the court?
The court, Your Honor.
Court heard, okay. I'm sorry, so when was the first time you heard about the alleged problem with the verification?
The first time we heard about it was after April 18th, where the court had its initial conference on this matter, Your Honor. It was not until after that date.
And who brought it up? The Board of the Board of Elections or the interveners?
The interveners brought it up, Your Honor.
Okay. And the first time you heard of it was after the 18th?
That's correct, Your Honor.
What was the date, do you recall?
I believe it would have been that Sunday, Your Honor.
You had a conference with the court on a Sunday?
We did not. What it was the interveners refiled their order, an order to show cause, and in that order to show cause, they mentioned it.
So when does it come up in the court below?
It came up in the court below on April 22nd. On April 22nd, we were back in court, and that was the first time that the court was able to address or hear of that.
But it's not mentioned in the decision.
Correct. It's not mentioned in the decision. And because of that, we would ask that the court not consider it now.
On April 22nd, when did you first hear about the interveners?
First heard about the interveners on April 18th.
And you had between the 18th to the 22nd to address the interveners' claims?
I did not. The way the court heard it was the court said we only had 3 days from when we filed to amend anything, including the verified petition. I asked for leave to file an amended verified petition, and the court said their position was we weren't able to because the time period had elapsed.
So you didn't have although the interveners were in court on the 22nd, you didn't have an opportunity to dispute their claims?
I certainly disputed their claims on the record, but I didn't have an opportunity
To file papers.
file or send anything, but I did seek court's
By the
permission.
time you hear about it, you don't have a chance to correct it.
That's correct, Your Honor.
Thank you, counsel. You have time in rebuttal.
Thank you, Your Honor.
We'll hear from the Board of Elections next.
Good afternoon, Your Honors. May it please the court, Susan Paulson on behalf of the Board of Elections.
So you don't even talk about the grounds, or you don't rely on the grounds that
Correct.
the court did. You go right to the merits.
Correct.
So Clarisse versus Clarissa.
Those are different names, Your Honor, and they could
And it's only on the
identify-
cover sheet, right? And the petitions that were signed by actual voters, it was always Clarissa, correct? That's correct, counsel. Tell me if that's factually correct.
The designating petition had the correct name, but the cover sheet did not. And the cover sheet has prescribed content, which is required to identify the candidate.
So it's I'm sorry, go ahead. But the content is, put your name, and there's no doubt that there was a name.
There was
right?
a name.
And the question is whether the name was close enough to the name, because we have tons of cases, including the Court of Appeals, who have said, as long as the content is all there, you can substantially comply with the form. So the question is, Clarice versus Clarissa, is that substantially complying? I assume you're saying that it's not.
Your Honor, actually, our argument is that substantial compliance does not apply here because it's not a matter of form, it's a matter of substance. The actual
Because
name
you're
of
also
the candidate.
you're also concerned about possibility of fraud.
Absolutely, Your
But
Honor.
what is the possibility of fraud here? The petitions are in the name of Clarissa. The original cover sheet is Clarissa, and there's obviously some sort of error made in the new cover sheet. So there really could be no doubt here that the candidate is Clarissa.
Your Honor, the amended cover sheet supersedes the original cover sheet. I'm not aware of any case law that applies a totality of the circumstances test as.
So may I interrupt you in just saying, you're not saying we can take them both together and
That's
make one good sheet? It's either
That's
the
correct.
first one is struck, and now we're looking at the second. There's no ability to take them together as one good.
Yes, Your Honor, nor are they read
I'm not
together with the
questioning that.
petition.
My point is that the possibility of fraud seems to be not really present here.
Your Honor, the name of the candidate is obviously an essential element of the cover sheet. It's a separate requirement from the designated petition. It did not have the name of the candidate here. Our argument is the substantial compliance rule does not apply under these circumstances, and the absence of the candidate's name on the cover sheet is a fatal defect. And for that reason alone, the petition should have been denied. If there are no further questions.
Thank you, Counsel.
Thank you.
Good afternoon, and may it please the court. Aaron Foldenauer on behalf of the interveners, Alexander Lorenzo Reyes-Pineda and Tomas Ramos. And respectfully, the interveners submit that the court need not reach the substantial compliance question because this action was not properly filed for two reasons. The court has already discussed the verification.
You posit that there's a duty of a candidate to see if anyone has objected to their petitions, whether or not they've been served with those objections. Is that right?
There is, and what
You're saying
the
that.
mistake that petitioner makes is that they're trying to graft on a service and receipt requirement onto the Court of Appeals decision in Gadsden. There is no such requirement in Gadsden. And if I may direct the court to New York Election Law Section 6144, with apologies, was not cited in my brief. And New York Election Law 6144 talks about a board of elections, quote, shall keep a book, unquote. And that book contains who's filed petitions and so on, and also includes, quote, a memorandum of any objections to such petition or certificate. So the Board of Elections in the election law 6144, is supposed to and does
Right,
keep a
but where
log
does
of
the
objections.
affirmative, counsel, where does the affirmative duty of each candidate to go check come from?
Well, it's in, number one, that's part of the Gadsden case, is that you have to make sure all objectors are named
Well,
and served.
the question is whether, in fact, there is an affirmative obligation on the candidate to do independent checks to find out who potential objectors are. Is that what Gadsden says?
If there were some sort of affirmative obligation, then what candidates would do, they would just stick their heads in the sand.
No, what would happen is that if there is an objector, that objector would follow the rules and make sure that they effectuate service appropriately to properly advise the candidate that there are objectors.
And here, objectors actually did that. The objectors
Wasn't
were
that 3 days? Wasn't that 3 days after the candidate had filed her petition?
It wasn't, Your Honor. It was April 7th. The initial objections were filed, and then the specifications were filed and served on April 14th. One day before this action was filed, and 2 days before the last day.
She says she received them.
file this action.
Doesn't the candidate say that she received them on April 18th?
She talks about receipt, but service, and this is the longstanding principle of service. Service is complete when it's, quote, deposited in the mail. Now here it's a FedEx overnight delivery, but service is complete when it's sent. The matter of receipt, or I didn't get the FedEx, or the dog ate it, that's not an exception to service. And if I may also refer to the verification issue, the court asked when this was raised. It was raised immediately. The first day in court was April 18th. Interveners showed up, and that was a Friday. The judge asked interveners to file an order to show cause with a proposed order to show cause on Saturday, April 19th. Interveners filed a proposed order to show cause on Saturday, April 19th, raised the issue of the improper verification. The judge signed the order to show cause a few days later, heard the issue, and ultimately rendered the decision below. So that issue was raised extremely promptly with notice, and petitioner did have a chance.
Well, how do you
to
respond to
that.
the fact that even the Board of Elections is not on appeal defending the trial court's decision to dismiss the petition on that ground?
I see the red light is on,
Please
but if I
continue.
may
No,
answer
go ahead.
the question. I think the Board of Elections is always interested in enforcing its own rules, which is my speculation as to why the board focuses on its rules and its compliance. But of course, interveners are here talking about these very two threshold questions as to whether we should be here at all. And interveners submit we shouldn't because of the failure to name objectors and the improper verification, which was timely raised and addressed in the papers below. Thank you very much for the court's consideration.
Thank you. A good time in rebuttal.
Your Honors, I would resubmit that interveners did not timely notify the candidate of any error, even if they're saying they notified on April 18th, which is not my recollection.
No, they're saying they notified you on April 14th when they sent their objections.
What they're saying is that they notified us by filing specific objections. However, those specific objections on their face is not enough if it's not received by the candidate on time.
So that's the question. Do we go from the time it's put in the mail or the time it's received by you? Because it is generally true that mailing ends the service.
It does, but it's also true that the court's order said that they could have served the candidate by in-person service, and they decided not to. And the reason the court said that was to make sure that candidates are aware. It's also important to note that on page 7 of respondent the board's papers, the board says the case law is less clear about whether potential objectors are necessary parties if the designating petition was rejected by the board due to defects identified by the board's own staff before the objectors served their objections on the punitive candidate. Here, that's exactly what happened. The board issued a letter dated April 11th, prior to April 14th, noting of its decision that it was going to invalidate the petition before interveners filed their papers. It's also important to note that there's a similar third department case that touches right on
Your bottom
this.
line in this is, I guess, that you shouldn't be faulted for failing to respond to a document which you didn't have.
That's correct, Your Honor, and that's exactly why in Dio Gardy versus Donahue, 207 A.D.2D922, the court addressed this exact issue and held that it shouldn't harm the petitioner and that an objector who's objecting for a reason that a board already acted on is not considered the necessary party.
How do you address the board's position that putting an incorrect name is not substantial compliance? I mean, there's no doubt the name is incorrect. It's not her name.
That's correct. I would also point that
I just want to know, how do you respond to that?
I respond that that's still a Scrivener's error that's aligned with this court's decision in Flax and also.
Well, we have other decisions that go the other way, don't we? That say that a name, that kind of error is is substantial enough to strike the petition.
They say that's the case when there's allegations of fraud or it could mislead the community. Clarissa.
Was there any factual finding here either way?
there were
How
no-
do we know whether there were, how could we make that kind of factual determination? Whether fraud is incredibly factual, right? Whether or not, what her intent was there any testimony about her intent below?
We argued to the court, but the court didn't hear it, that it was a Scrivener's error, and we did have the candidate there at the time of the hearing.
Well, we can see from the previous cover sheet, right? If there was any intent, then the name
Correct.
wouldn't have been correct on the previous cover sheet.
Correct.
Understanding that we don't take them together as one cover sheet.
That's correct. And I would also say that even the court, in rendering its decision, misspelled the candidate's name.
Multiple times.
Yes. And certainly, if we're here because of the court's decision, then I would say that certainly this is a Scrivener's error. And as such, we respectfully ask that our candidate be put back onto the ballot, Your Honors. Thank you.
Any further questions? Thank you. Thank you all.
Thank you. Thank you. I'm sorry, I didn't get to introduce myself or say hi. I just wanted to say hello.